Okay, good afternoon, everybody. Today is Tuesday, August the 27th. My name is Judge Esparza. We have some writ hearings scheduled for this afternoon. The defendants are present in the courtroom. They have been sworn in. First case we're going to call is C-3858-24-H, State of Texas versus Gerardo Ayala. Speak English, Mr. Ayala? You do? Okay, just stand up in the middle of the room there. Right there's fine. And face the TV monitor. Move back a little bit. Face the TV monitor. Mr. Ramos, were you detained? I'm sorry, were you retained on this case? Because it showed Morales. Where, Mr. Ramos?
Yes, we're retained. Yes, sir.
Okay, no problem.
This one called 3 times, no response.
Your client's present. He does speak English. You may proceed.
Thank you, Your Honor. As we stated, Your Honor, we were retained to represent Mr. Gerardo Ayala by his family. He's charged with 6 counts of indecency with a child by contact. Each count is currently set at $50,000 per bond for a total of $300,000. Respectfully, Your Honor, it's our position that bond is excessive to the point of it's a violation of the 8th and 14th Amendments of the Constitution, Article 1, Sections 11, 13, and 19 of the Texas Constitution, and Article 17, 15 of the Code of Criminal Procedure. As the court knows, bond is not to be used as a tool of oppression, but only to assure the defendant's appearance in court. He's a 36-year-old U.S. citizen, Your Honor. He's got 0 priors. He's got a long work history in the Rio Grande Valley. He currently works at DHR as a chef there at the hospital, but previously he was working at a Brook Ridge assisted living for about 2 years. He's a U.S. Army veteran, Your Honor. He served from 1997 to 2005, honorably discharged in 2005. He served in Afghanistan one tour, in Iraq also one tour, Your Honor. Got very strong family ties. All his relatives live here. Didn't have any relatives in Mexico. Doesn't frequent Mexico other than, an occasional, going to pick up some antibiotics, 5 years ago or something like that. But he does not frequent Mexico, Your Honor, and would be willing to give up his passport if necessary as a condition of his bond if he was released. The length of residency, Your Honor, he's lived in the Rio Grande Valley his entire life, mostly at the address at 1102 Paisano Drive in San Juan. That's his permanent address. And that's
Ramos, hold on just a minute. We're getting a lot of noise. I think you're banging your microphone or something.
That's exactly what I was doing, Judge. I was hitting the papers. I'm sorry, Your Honor.
Okay. No, that's fine. You can proceed.
I'm going to repeat, Your Honor. I think I was he's lived in the Rio Grande Valley his whole life. Released, continued to live at 1102 Paisano Drive in San Juan. That's his permanent address. He's got no prior run-ins with the law at all, Judge, no prior criminal history. As far as conformity with previous bond conditions, well, he's had no run-ins with the law, so he's had no opportunity, but he's never had to comply with bond conditions. But I will advise the court that he was reached out, about 10 days before his arrest. The investigators did reach out to him. He did know he was under investigation. He didn't flee. He stayed here, Judge. There are really no aggravating circumstances. Obviously, the charges are very serious, but considering the charges, there are no aggravating circumstances. I will point out that these did arise after a breakup, and then our client finding a new romantic interest. I will further add that the allegations are coming from an individual who has served federal time, who is revoked on supervised release, and is battling drug addiction. That we'll take up at a later time, but all those factors we believe should be considered. In addition, Your Honor, I've already stated he's a U.S. citizen, but the ability to make bail, as the court knows, can be taken into consideration. His family has about $4,000, Your Honor. We're asking, well, it's our belief, Your Honor, that there are conditions or combinations of conditions that the court could impose to, number 1, assure his presence in court, and number 2, assure the safety of the victim in the community. We would be willing also, obviously, to agree to any kind of no contact order or any other condition the court would deem reasonable to impose upon him to meet those 2 goals of bond, Your Honor. We're asking the court to impose a bond of $6,000 per count for a total of $36,000. Again, we believe that that amount, with any other conditions, would assure his presence in court and would assure the safety of the community, Your Honor.
What says the state?
Good afternoon, Your Honor. On the record for the state would be opposed to any bond reduction, Your Honor. In this case, the defendant is charged with 6 counts, Your Honor. They each involve minor children under the age of 17. We have multiple minors involved in this case, Your Honor. Given the very serious nature of the offenses and for the safety of the victims, Your Honor, the state would be opposed to any bond reduction in this case.
Mr. Guerra, I didn't see any prior history. They indicated that there's nothing, right? Or is there any federal or anything?
I did see a misdemeanor possession of marijuana, Your Honor, in 2003. But other than
I
that,
saw that.
I apologize, Your Honor. I did not see that. I did not mean to mislead the court, Your Honor. It was my understanding that he had no priors. I apologize for that.
No, and that's fine. That's the only thing I saw too, is that prior POM. I didn't see anything else. I didn't see a protective order issued in this case. I will advise the defendant that if you do make bond, sir, you have no contact with the victim or alleged victims. That's text messages, phone calls, any type of contact whatsoever. Do you understand that? How old are you, sir?
37.
How long have you been working at DHR?
I just started there, so maybe like a month and a half.
Prior to that, you were where?
At Quick Rich Retirement Living.
I'm sorry, where?
Quick Rich Retirement Living,
How long were you there?
2 years.
Doing the same thing? Good.
Sir. Yes, Your Honor.
And I'm gonna ask that you have no contact with the victim or alleged victims.
okay.
Bond will be reduced to $6,000 cash surety. 6 count. I'm gonna ask that he be released to AIP officials. AIP, sir, is basically house arrest. You can go to work, but you have to provide them, the AIP officials, your schedule, the hours that you're gonna be working. They'll go check to see if you're at work like you're supposed to. If you're not working, you need to be at home, and they'll go check. And if you're not home or at work like you're supposed to be, that's a violation. It'll be reported back to the court, and you could end up back in jail. Do you understand that?
Yes, Your Honor.
It'll go on, and you'll be under AIP until I say otherwise, or until another judge releases you from that program. Do you understand that? Any other conditions, Mr. Guerra, that you feel need to be imposed?
No, Your Honor, just that he have no contact with the victims in this case.
And took care of that. He'll be released to AIP officials only, so we'll prepare the order, Mr. Ramos, and then we'll contact AIP. They'll come and visit with him, have him sign the contract. And once his bond is posted and they take care of those arrangements, he'll be released.
That's all I have, sir. May I be excused?
Yeah, stay in contact with your attorney, you understand?
Yes, thank you, Your Honor.
All right. Sir, thank you, Mr. Ramos. Case we're gonna call is C 3885-24-E, State of Texas versus Juan Garcia. No hablas inglés, ¿verdad, señor? Yeah, Mr. Garcia is present. He is Spanish speaking. Jesse Contreras. This is your motion. Jesse.
Your Honor, good afternoon. Jesse Contreras for the record, representing Mr. Garcia, Your Honor. He's a 39-year-old man with no prior criminal history, Your Honor. This is a second request for coming before you, Your Honor. There was attempts to cover the $50,000 bond on the possession of controlled substance and the $50,000 bond on the organized criminal activity. It's just the family right now it can't even come up with the $10,000, Your Honor, that is required of the two bonds, that will reduce, and we appreciate that reduction, Judge. What we're seeking is 5,000 cash surety on the first one, the possession of controlled substance, and for the first one. And the second one, we're asking for the same thing, for the 5,000 as well, Your Honor, for the engaging in organized criminal activity. And again, we already, the background of Mr. Garcia, I think we dealt with it the first hearing, Your Honor. On the second hearing, I do want to stress that he's got no criminal history whatsoever. He's 39 years old. He's been in jail for 38 days already, Judge, as well. And it hasn't been indicted yet.
Does have an ISO too. I don't know
He
if you
does?
remember
Oh, wow.
Yes.
I forgot about that. That's right.
And yes,
But
Your Honor,
since
the state's position, Your Honor, is that the state would be opposed to any bond reduction in this case. Citing Article 1715, that the court shall take the status of the defendant to be considered. As the court is aware, this defendant does have an ICE hold, Your Honor.
Well, it's not a mandatory condition, or should I say provision, Your Honor. But you have to consider that, and I recognize that from the state that he does have an ICE hold. Just in lieu of that, I'm asking for a $10,000 cash surety, and then another $10,000 on the second charge, Your Honor.
yeah, no, and I'm aware that it was previously set at 150. I did reduce it to 50 on each count at one point, I think about 2 weeks ago.
Yes, Your Honor.
Mr. Garcia, you're aware that you have an immigration hold on your case, correct? We discussed this before, correct? What I'll do is on the engaging in organized criminal activity, bond will be reduced to $10,000 cash surety. Bond on the possession charge will be reduced to $30,000 cash surety.
Thank you, Your Honor. Apologize for, I was in a hearing right now, so I apologize for logging in late, Your Honor. But again, thank you for
Your
the
time.
reductions, and that's all I have before the Honorable Court. May I be excused, Your Honor?
Yes, sir. Thank you, Jesse.
Thank you so much. Mhm.
Toma asiento, señor. Next case we're gonna call is C 3829-24-8, State of Texas versus Luis Huerta.
Francisco Gonzalez, Mr. Huerta, Your Honor.
Do you speak English, Mr. Huerta? You speak English? Okay, just stay right there, that's fine. Paco, he speaks English, you may, it's your client, you may proceed, sir.
Your Honor, his bond is currently set at $5,000 cash or surety. We'd ask that Your Honor consider lowering it. He's HIV positive, Your Honor. He's not getting his meds in jail. And as you know, if you've ever heard about it on the media, that if people who are HIV positive stop taking their meds, they run the risk of their viral load increasing and not being able to get it under control. He's not getting his meds, Your Honor, and the bond is beyond his ability to pay it.
What are you asking?
We'd ask that he be released on PR, Your Honor. He still has a case which is in County Court 7. I'll ask Judge Valdez to lower the bond on the misdemeanor, which he probably will, but the felony is way beyond his ability to pay, Judge.
This is an aggravated assault, I believe.
Yes, Your Honor.
What says the state?
Your Honor, the state would be opposed to any bond reduction in this case. The defendant has a very lengthy criminal history, Your Honor. Very lengthy aggravated assault causing bodily injury, aggravated assault with deadly weapon, ag rob, burg hab. The list goes on and on, Your Honor. The state does believe that the bond currently set is fair. Therefore, Your Honor, the state would recommend no reduction in this case.
I did review his criminal history. I saw over 50 prior arrests, going all the way back to 2001. $5,000 cash surety bond on an aggravated, second-degree aggravated assault charge seems rather low to me. Based on his prior history, and the facts of the case and the charge, I think the bond is fair and reasonable, and I'm gonna ask that I'm gonna order that the bond remain the same.
One other request, because this is on a habeas, Judge. If Your Honor can send some requests to the infirmary that he gets his meds, Judge. This is a habeas, you have some of that authority.
All right, we'll notify the infirmary. Sure, they've evaluated him prior to him coming in, or since he's been here, because that's part of what they do. But if not, we'll notify them to review those things. He's been in jail now 18 days. I mean, the bond, in my opinion, is fair. It's only $5,000. Based on his criminal history and the facts of this case, I'm gonna order that the bond remain the same.
Los charges I signed because I wanted to get out. I was not guilty.
Well, when you sign those documents, sir, whatever, I believe you're signing about plea papers, you're signing and saying that you were guilty of those charges. Whatever reason you did it for, by signing it, you were stating you were guilty. So they show up on your record that you were guilty. And you've got, like I said, you've got a lengthy criminal history going back 20 years. You're in and out of this place.
Mostly I for the past years.
Where do you live, sir? Where do you live? Do you live on the streets or do you have a home?
I don't know much about my mother.
What city?
Okay.
How old is your mom? How old is your mom?
She's 67. She's very sick.
How old are you?
I'm 48. I don't feel good at all. I'm vomiting, diarrhea, and night sweats and fevers. And the meds are too expensive. The county doesn't want to pay for them. I got the cirrhosis of the liver and not taking treatment. I have everything off.
Based on the information that I have, I'm gonna leave the bond the same, so go ahead and have a seat.
6 days, but I was also scheduled for an examination trial today in the 389 court.
Okay, that you need to speak to your attorney about when he comes to visit with you.
It was at 2 o'clock.
Go ahead
This,
and have a seat.
if I may, Judge, this is the examination hearing, mister. This is the hearing on your bond reduction motion, Mr. Huerta. There's no other hearings.
There's no probable cause to be here.
There-
I never assaulted anybody.
This was a bond reduction motion.
That's not what the papers say.
Sí, sí, bueno, ahorita we'll continue with the rest.
Can I
Thank
be
you, Mr.
excused?
Gonzalez. Yes, sir.
Thank you, Judge. Have a good day.
To the next case, we're gonna call is C 3889-24-I, State of Texas versus Juan Longoria. You speak English, Mr. Longoria?
Yes, sir, Your Honor.
Your attorney is Victoria Guerra Picasso, and speaking there, Victoria?
Yes, Your Honor. Excuse me, I'm just driving back from La Villa, so I'm a little bit indisposed, but I've not met with my client personally, so I'm sort of limited in the information I have. I believe that he's charged with an evading arrest with previous convictions, and then there's another, let me see. The court will allow me just 1 minute.
I'm not sure if you're aware, Victoria, but he does have 2 felony MTRs that are currently set with no bond.
Yes, Your Honor,
I
that's correct.
see. Okay, Your Honor, at this point, I'd like to withdraw my motion to my writ of habeas corpus. Will be filing a non-suit.
Mr. Longoria, you have 2 motions to revoke on 2 felony cases. The allegations on those cases are basically that you haven't reported and not complied with the conditions of the bond or the probation. There's no bond set on those cases. Your bond on this case is set at $10,000 and $2,000. into that. Your attorney's gonna file a non-suit, meaning gonna work to take care of those cases first. Because even if you were to make bond here, you're not getting out of jail because you have those two motions to revoke pending. You understand that? All right, good luck to you, sir. Go ahead and see.
May I be excused, Your Honor?
Yes, thank you, Latoya.
Thank you. Have a good day.
You too. Next case, we're gonna call it C 3867-24-F, State of Texas versus Juan Mojica. You speak English, Mr. Mojica? Yes? Right there's fine, right there's fine. Just face the TV monitor. Tanya Ramirez, this is your motion. You may proceed. Oh, where'd she go? I thought I saw her on the screen. I guess she logged off. All right, we'll recall it. Go ahead and have a seat, sir. We'll call your case back in a few minutes. Next case, we're gonna call 3831-24-I, State of Texas versus Ricardo Salinas.
Good afternoon, Judge. Hector Bush on behalf of
Good
the defendant, Judge. Mr. Salinas is not charged with murder like yesterday, Judge, so I will not be
Hector-
requesting PR on the murder. But nonetheless,
And
Judge,
just so you, hey, hold on just a minute, just so you're aware, he also has a motion to revoke out of, it's a felony motion to revoke on a motion to adjudicate out of the 93rd District Court.
well, Judge, with that said, Judge, I'm gonna withdraw my motion. I didn't have it on my notes. I think
Yeah, I think it just got filed yesterday, Hector.
Okay. I apologize about that, Judge. So we'll withdraw from that, given the fact that even if he gets PR bond, he has that adjudication pending. So sorry for taking the court's time, Judge.
No problem, Mr. Salinas. You speak English?
Yes, sir. I got something to say to the court.
Hold on just a minute. You have a motion to adjudicate out of the 93rd District Court on a felony case, which means you violated your condition, or they're alleging that you violated the conditions of your probation. It was just filed yesterday. So even if you were to make bond on this case, you wouldn't get out because that case is holding you. So your attorney is going to withdraw the motion to reduce the bond and address that case first, and then he can at a later time come back and ask that this bond be reduced for right now. Do you understand that?
Yes, sir.
All right, go ahead and have a
Thank you,
seat, sir.
Judge.
Good luck to you.
But I gotta say something to the court, Your Honor, because I got a problem, I got an issue, because I hear voices and I control people's mind.
Can't let you out of court, sir. I don't have control over that other case. You're gonna have to go in front of that judge, and you can make that argument, see if he gives you a bond. Right now, he's not giving you a bond, or there's no bond set.
All right,
So
I just think you guys to know that.
Okay, I'll advise the infirmary. Somebody on the iPhone here, let me see who that is. Doesn't have a name on it. Hang on just a minute, Andres.
No problem, Judge.
Whoever has the logged on their iPhone, can you please turn on your camera? Please turn on your camera. Whoever has the iPhone. Yeah, we had two other cases set this afternoon. Turn on your camera, you will be removed.
Let me see.
Okay, well, I had them removed. They didn't turn on the camera. The only attorneys we had left are, let's see. C 3883-24-A, State of Texas versus Orlando Flores. You speak English, Mr. Flores?
Yes, sir.
Your attorney is Carlos Jaime Garza. It's now 2:30. I don't see him on the screen. Have you had any contact with Mr. Garza on this case?
Yesterday, he told me about, he advised me about this.
So you did speak to him yesterday? Yeah, it's unusual. He's not here. Andreas, have you spoken to him or do you have a recommendation on this case?
I have not spoken to Mr. Garza, Your Honor. As far as a recommendation, the state would recommend no reduction in this case, Your Honor.
Mr. Flores, your attorney's not present. The state's not recommending any reduction. You have 2 felony cases pending, an evading arrest and an injury to a child that are set for arraignment in the 370th District Court on the 5th, which is in about 2 weeks. Your attorney is not present. You're charged with an aggravated robbery. I read the complaint. At this point, you've been before me before. You were here not too long ago. Looks like, well, back in April, where I reduced your bond on that evading. At this point, I'm going to ask that the bonds remain the same. Meaning that you're out already on 2 pending felonies, and then you picked up another 3rd one. So I'm going to leave bond as is. Your attorney can request at a later time to reduce it. I'm going to leave it as is. All right? Go ahead and have a seat. Good luck to you. Mr. Mojica, go ahead and stand up right there where you're at. Stand up right there where you're at. Just, your attorney was here earlier, sir. This is C 3867-24F. Your attorney was on the screen earlier. I don't know what happened. She seems to have logged off. Tanya Ramirez, and she has not logged back on. We're going to go ahead and leave the bond as is. And if she wants to refile it or re-urge the motion, she can do so at a later time. You understand? Okay. All right. Yes, that's all we have for today. Thank you for your help.
If I live here, who can pay, if my mom is 5, Santa Clarita, can she still pay for the bond, my boy?
Say it again, I didn't
If
understand.
my mom is in Santa Clarita, can she still pay the bond, the money and pay for it here?
Raise the bond, yeah, you can be released.
How much is it?
I believe it's $20,000.
Cause they say it's 2, that's 20,000.
One at 20 and one at 2,000. 22,000, yes.
So it's like 4,000, right?
The bondsman usually charge you 10 to 15%, so between $2,000 and $3,000, depending what they charge you. You'd have to negotiate that with the bondsman. All right?
You guys have a number of it?
Do we have a what?
A number of this?
There's multiple bondsmen. You can pick whichever one you want.
No, I already have one. They already assigned me to one. They already give me one.
Okay, then you negotiate that with yourself. We don't have any control of that. I can't tell you who to use. All right. Andreas, thank you for your help.
Judge, thank you.
Have a good afternoon.
You too, Judge.